and thank you all for joining us today. Although I recognize after I said good afternoon that it still may be morning time for some people on the West Coast. My name is John C. Yang. I am the President and Executive Director of Asian Americans Advancing Justice, AAJC. I will be moderating today's discussion on key voting rights issues at play in the 2026 election cycle. I am pleased today to be joined by an incredible group of experts and, I dare I say, friends and colleagues in the Voting Rights Working Group, a coalition of leading national and civil rights organizations that work together to protect and advance voting rights and communities of color across the country. So we have today Tom Saenz, who is the President and General Counsel of MALDEF, the Mexican American Legal Defense and Educational Fund, Taifa Smith Butler, who is the President of Demos, Lourdes Rosado, who is the President and General Counsel of Latino Justice PERLDEF, Adriel Cepeda de Roo, who is the Deputy Director of the Voting Rights Project at the ACLU, and Jacqueline De Leon, the Senior Staff Attorney at the Native American Rights Fund. And the issues that we are going to talk about today is different issues around voting. So that includes systemic barriers to voting, voter access and interference, SCOTUS decisions and their impact, enforcement of the Voting Rights Act, and State Voting Rights Act and their impact on the elections. Now, just a table set, earlier this month we commemorated Bloody Sunday, the brutal attack on Black voting rights activists that galvanized support for the passage of the Voting Rights Act in 1965. That bedrock of civil rights law is now being challenged in courtrooms across the country, including at the Supreme Court, by modern-day opponents of equal access to the ballot box for communities of color. This is terrible for our Black, Asian, Latino, and Native American communities, and it's terrible for all of us. Because when voting systems are unlawfully manipulated and do not reflect the will of the people, the promise of our democracy is at risk for everyone. And I want to be very clear about this. This is not about partisanship. The people that will hear from are not partisan. We are civil rights activists, believe in an open ballot box for everyone. At its core, this is about whether all of us as eligible voters, regardless of who they are and regardless of where they live, have a fair and equal opportunity to have their voices heard. We should not depend on Democrats, Republicans, or any political party to ensure that all voters have their voting rights protected. The fundamental mission is to ensure that everyone has equal access to the ballot box. Then that falls to civil rights organizations dedicated to protecting and strengthening our constitutional and civil rights. Because at the end of the day, partisan actors will only defend the voting rights of communities of color if it helps their candidates to get elected. Nonpartisan organizations play an indispensable role in ensuring that communities of color have their voices heard, regardless of their vote choice. That's what today's conversation is about. So with that, let's get started. And to start us off, we want to start by talking about systemic barriers to the ballot. And I'm honored to have Taifa Smith Butler joining us from Demos to kick us off. And the question I would pose to you, Taifa, is this, is when we talk about voter systemic barriers, one thing that comes up is voter purges, getting people off the voting rolls. So I would ask you to talk a little bit about how voter purges have been used to suppress voters of color, especially, and others from participating in our democracy.
Thank you so much, John, for that question. And I would be remiss if I don't also sort of plus one to your context setting for the moment and think about sort of all the ways in which we want to ensure that people have their political power expanded and supported in this country as we think about the backdrop of our democracy and our democratic norms seemingly to be dismantled right now. And so when we think about that, and then the historic efforts to use the ballot box as a way to limit people's ability to have agency and control, not only over who represents them, but also how they can inform the policies that can really help inform their and improve their lives. So I'm so glad we're having this conversation because we as the civil rights community and voting rights community and democracy defenders really have to be hyper vigilant right now as we think about this. And so I usually group the systemic barriers in three buckets. I think about roles, polls, and trolls, and how they actually hinder our ability to exercise our political power. And the question you posed to me, John, was really about the roles and the ways that we who believe in a multiracial, pluralistic society, who want to ensure everybody has access to the ballot, that we we have an expansive and inclusive electorate, the states who are the ones who manage and administer our elections have used the data hygiene and voter list maintenance as a way to really hinder people's ability to be eligible voters or registered voters, or whatever ways that they've used in different states to create the eligibility requirements for people to cast their ballot and to exercise their political power. And so we've seen these systemic efforts with voter purges that has had disproportionate impact on Black, brown, young people, low-income people, low-propensity voters, because states have used inconsistent processes to actually maintain their lists. And these are the things that we've at Demos have advocated for through the work of our voter purge table with many of you, is to ensure that states are practicing good hygiene, data hygiene, and using those maintenance efforts to, remove people who are passed away or to remove people who have moved away. But systemically, their decisions around inactive voters have really, again, harmed voters of color. And we could see this in places like Georgia just last August, who did one of the largest voter purges in their history. Nearly 500,000 people that were purged in August because of inactivity. And again, I think as we think about these ways to ensure that we have people who understand that their rights and their power as voters to be able to show up to their polling place, to know that they're on the rolls, these are ways that they have systemically kept people hemmed up in terms of these voter purges. And that's problematic at the state level. We also know that they purged too close to election cycles. That Alabama recently did this. Florida, I believe, recently did this. When you get so close to an election and then you purge people and then they realize that they're not eligible to vote, that also is, again, the inconsistency in voter maintenance that we believe is systemically targeted to make sure that people can't cast a ballot. So those are the areas that we believe are really important to watch in the state practice. And our other concern is the federal government's new efforts to try to get unredacted voter registration files from the states so that they can either create a master file or also use some of the national databases to do some testing and some matching, which we believe will be harmful. So we're excited that states like California and others have won in the courts right now, and they're protesting and pushing back against the federal mandates of collecting the voter rolls. But this, I believe, is another effort that we have to watch, that the federal government might try to use the rolls to actually do mass purges, and that can also be a problem for everyday voters. So those are the things that we're really concerned about when it comes to the polls, or the rolls, I should say. And I know my colleagues here today will talk more about the challenges of people actually accessing the polls to be able to cast their ballot, and then also the concerns about the trolls like violence and other intimidation tactics that will keep people from their political power.
Great, thank you very much, Taifa. And for those that are watching, if you have questions, you could put them in the Q&A box in the below, and then we will get to those after all of our speakers have a chance to give their presentations. Next, I appreciate what you're saying, Taifa, about polls, because our next speaker, Tom Sainz with MALDEF, will talk a little bit about polls and specifically around voting access and what poll interference might look like. In particular, and I think this has been literally in the headlines the last couple of days, is around the notion of voting in person. And so the question I would pose to you, Tom, is, voting in person has become more contentious in recent years. So what concerns do you have about the 2026 election, potential interference at the polls, including the ability to have voters receive assistance when voting? And Tom, you are on mute still, sorry.
Thank you, John. So we are concerned that the efforts to restrict remote voting is entirely about making it more difficult for registered voters to participate. Certainly, it makes it impossible for some voters who, because of age or disability, may find the act of actually voting in person at the polls to be impossible. But our bigger concern for broader numbers of voters is that when you force folks to show up at the polls, then they are potentially subject to efforts at intimidation. And we cannot dismiss the possibility that even the federal government, through executive order or otherwise, may engage in activities, including deploying immigration agents or other federal agents, FBI, etc., at or near polling places where significant numbers of voters who do not support the president will be seeking to cast a ballot. Well, those efforts would be illegal. If they are undertaken, it takes time and court attention to prevent those efforts from continuing. Obviously, that's not the kind of thing that we can necessarily prevent ahead of the election. So that's a great concern about intimidation. It's also a concern with respect to private intimidators who may be encouraged by the White House through executive order or other pronouncements to engage in their own do-it-yourself attempts to intimidate particular voters from casting a ballot. And that may mean private individuals putting on security uniforms, perhaps in certain states even carrying firearms at or near polling places of great concern. So these efforts too, it is difficult to prevent through court action in advance. So these are things we prepare for, but that we may not be able to act upon until the day of the election. And as you mentioned, John, there are also concerns that even those who may freely access the polls may find that they are denied their absolute federal right to have an assister of their choice in casting a ballot. The Voting Rights Act guarantees every person who is not literate in English the opportunity to choose an assister of their choice, as long as it's not their employer or labor rep, to accompany them to the polls and provide them with assistance in casting their ballot. We have already seen restrictions by states on this right to voter assistance, and we may see more attempts on the day of the election by local precinct officials to deny that really ironclad right to voter assistance from an assister of your choice for certain voters. So there are a number of concerns, too many of them likely to occur on election day itself, that raise concerns about intimidation, about preventing, through denial of assistance, the right to cast an informed ballot. And these are things that we are already months ahead thinking about with respect to both primary and general election. Thanks, John.
Thanks, Tom. Actually, I'm going to ask you a follow-up question along what you just talked about in terms of the assister of your choice. Obviously, this administration has issued an executive order as English as the official language of the country. Now, how does that executive order juxtapose against, section what you've referred to as Section 108, the assister of your choice, which we all understand to mean an assister that speaks a different language than English?
So Section 208 of the Voting Rights Act, as duly enacted congressional legislation, cannot be overruled by an executive order of any kind from the president. So Section 208, on the books now for decades, makes clear, as you said, that every person who is not literate in English has the right to choose their assister and to bring that assister with them to the polls to help in casting a ballot. No executive order can overcome that. But again, it is a concern about what may occur on election day that may be unlawful, but that requires immediate action in court to overcome.
Thanks, Tom. I really appreciate that, because I think part of this is what we all want to do is dispel the confusion that might be arising among communities about all of these conflicting signals that we're seeing. And I appreciate you also talking about the need for court attention, and I think that leads directly into the next topic, with respect to Supreme Court decisions and just generally litigation around voting rights. And so we're happy to have Adriel Cepeda de Roo here, who is the Deputy Director for the Voting Rights Project at ACLU. So Adriel, can you tell us a little bit about sort of what is happening, especially in the Supreme Court space, maybe focusing in on the Calais decision and what impact that might have on the 2026 elections?
Yes, thank you, John. I can speak to the Calais decision, and tomorrow is decision day at the Supreme Court. The court may announce decisions tomorrow, so it means that we truly might be on the eve of what might be one of the most consequential voting rights cases, not just in a generation, but since the civil rights era. In a case called Louisiana versus Calais, which you just mentioned, which the ACLU has litigated with the Legal Defense Fund on behalf of Louisiana voters. The court is being asked to say whether addressing racial discrimination under Section 2 of the Voting Rights Act of 1965 is itself discriminatory. We think the answer is pretty easy. It's not a hard question. The correct result here would be for the court to uphold the Voting Rights Act and reaffirm that racial discrimination in voting has no place in our political system. But we are clear-eyed. The answer that the court settles on could define the scope or even the constitutionality of the VRA, not just for Louisiana, where this case comes out of, but nationwide. And if the court rules against voters, it would be a profound setback for multiracial democracy. It could roll back protections and strip voters of one of their core and meaningful legal defenses for over 60 years. And it could empower bad actors to intimidate or interfere with elections along the lines of what Tom spoke of. We have to be very clear on that. I do think what we do know as we head into November is that even if the court does rule in that way against voters, the maps and rules that voters will vote under in this November have largely already been set. And even a ruling that goes against voters in the Calais decision, even if it would be a serious blow, it should not stop, and we would encourage voters to not let it stop them from making their voices heard. The movement for voting rights has weathered devastating setbacks before, and it's kept fighting, and this would be no different. So whatever Calais may bring, voting rights advocates, many, including the groups that are gathered here, are watching, are ready, and we believe every voter should also be ready to go out this year and make their voices heard very loudly at the polls.
Great, thanks, Adriel. And one of the things that Adriel's talking about in terms of the litigation, this is litigation that's being brought by LDF and ACLU. And so they are nonprofit organizations, but they are considered private organizations. One of the other things that's been coming up is whether private citizens, whether private organizations can challenge voting rights laws. And so there's a case called Turtle Mountain that is addressing this issue. And so next I'm going to ask Jacqueline De Leon of NARF, the Native American Rights Fund, to talk a little bit about that case and other cases that you're tracking that could be impacting the upcoming elections. Jacqueline.
Thanks so much, John. Adriel spoke to how Section 2 of the Voting Rights Act has never been more vulnerable than this moment. In Turtle Mountain v. Howe and companion cases brought by ACLU, LDF, and MALDEF, a radical theory has been put forward by our opponents, alleging that private plaintiffs, meaning those that are actually impacted by discrimination, don't have a right of action under any theory and therefore cannot bring Voting Rights Act cases at all. This view goes against text, 50 years of precedent, and common sense. But this was nevertheless adopted by the Eighth Circuit in Turtle Mountain v. Howe. If affirmed, Turtle Mountain would effectively leave the Voting Rights Act an empty shell, leaving citizens harmed by racial discrimination no recourse except to wait for the DOJ to bring cases on their behalf. The vast majority of cases brought under the Voting Rights Act have been by private plaintiffs, asserting their own rights and seeking justice. We are currently waiting on the Supreme Court to take action on our cert petition. But what Turtle Mountain represents is not just an existential attack on the Voting Rights Act. It's the culmination of a multi-pronged effort to make it more difficult for certain, often minority voters to vote, to have those votes counted, and to seek recourse when that process is tainted by racial discrimination. Another example of this is in Watson v. Republican National Committee, a case where oral arguments were held just yesterday. At stake in Watson is whether ballots that are cast by Election Day but received after Election Day by Election Day officials can be counted. If found they cannot, this would upend the laws in over a dozen states that accept mail ballots after Election Day. Such a decision would have a devastating effect on Native voters in particular, who often reside on reservations where there's no residential mail delivery, where they must travel 20, 50, or even 100 miles to a rural post office, and whose delivery times from those post offices are slow and unpredictable. In places like Alaska Native villages, Native voters may have no choice but to vote by mail, and their ballots may be delayed through no fault of their own due to infrequent mail pickup times and weather delays, particularly in wintry November. In some villages, the number of ballots that arrived after Election Day was over 50%. And in some elections, some villages are disenfranchised entirely when their ballots do not arrive even within the extended timelines. Timely mail delivery is a significant hurdle in Alaska and throughout Indian country. It is no coincidence that this potential rule change with such a consequential impact could occur when there's a close Senate election race to be held in Alaska this year. The design and impact of these changes is to silence particular voices on the margins. So NARF and all the members of this coalition will continue to fight and push back against this ever-changing landscape.
Thank you very much, Jacqueline. It does occur to me, like when we're talking about mail-in ballots, I think what I read was about 1 in 3 ballots were through mail or early voting. And in terms of the impact, certainly for speaking for the Asian American community, about 2 in 5 of our community don't vote in person. And part of this is language issues, is making sure that we're able to understand the ballots, we're able to consider them and not have fear the pressure of being at the polling place. To Tom's point, also, it's about sometimes feeling like you are being intimidated or feeling to be put in a very uncomfortable situation at the ballot box, whether there are ICE agents or other people there that you feel like is putting pressure on you to vote in a certain way. So very much appreciate sort of how you're thinking about these issues. The other issue that comes up when we're talking about private right of action is just like, what does this potentially mean for voters outside of the private right of action? What this means for the Voting Rights Act? So I'm going to go back to Tom and ask, like, how does this private right of action affect other aspects of the Voting Rights Act? And what could that mean for voters coming into this midterm 2026 election?
Can you hear me now? Thanks, John. So one of the cases that's also being considered for review by the Supreme Court involves voter assistance. As we've discussed, the Section 208 right to choose your assister of choice. The state of Arkansas has a limit of 6 voters that any assister can provide assistance to in any election. And if you are the 7th voter who wants that assister under Arkansas law, you cannot be assisted by that person because they would be violating criminal law and guilty of a misdemeanor. So we challenged that law under Section 208. And as Jacqueline indicated, in the course of our case moving forward, in other cases, including Turtle Mountain, the 8th Circuit rejected a direct private right of action under the Voting Rights Act and further rejected the ability to use 42 U.S.C. Section 1983, a long-standing provision available to challenge the denial of individual rights protected by federal law, rejected 1983 as a vehicle to enforce the Voting Rights Act. So we were left with arguing that this voter assister limitation in Arkansas is preempted by federal law and therefore a violation of the Supremacy Clause. Incredibly, the 8th Circuit panel rejected that as a grounds to enforce Section 208 of the Voting Rights Act as law at all. So again, we're in a situation where every avenue is foreclosed to guarantee and protect the rights granted under the Voting Rights Act. In this case, that vehicle of preemption as a claim under the Supremacy Clause, the Supreme Court has made clear is available to achieve injunctive relief in every area of the law. And all of a sudden, through that panel's decision, the Voting Rights Act becomes the only exception. Cannot be enforced according to the Eighth Circuit under the Supremacy Clause through an equity action in preemption. Now that's extraordinary. In our case called Arkansas United, we have petitioned for cert, and the Supreme Court has recently directed a response be filed by the defendants. But there is no clear indication, unless the Turtle Mountain case is taken up and resolved the right way, that we would be able to enforce federal guarantees like Section 208 of the Voting Rights Act in federal court.
Great. Thank you very much, Tom, for helping us to understand even more of what's going on in the courts. I think, up until now, we focused more, well, not more, we focused on the Federal Voting Rights Act. And one of the things I think it's also useful for us to examine is what is happening at the state level. So I'd like to turn this over to Lourdes Rosado, who is with Latino Justice ProDef, to talk a little bit about sort of recent pushes to have state voting rights acts passed in different states. And if you could discuss a little bit of how your organization, as well as MALDEF, have tried to pass model state VRAs that can help, again, increase access to voting for eligible voters.
Yeah, thanks, John. I mean, as we all know, the Supreme Court has already weakened the Federal Voting Rights Act through cases like Shelby County, which eliminated pre-clearance requirements for jurisdictions that had, a noted history of discrimination and voter suppression. And as we heard from Tom, from Adriel, from Jacqueline, the federal VRA continues to be under attack. We await Calais, we await Turtle Mountain. All of these, if they go the wrong way, can further weaken the right to vote. So, of course, a number of the groups on this briefing, as well as other allies out there, we're vigorously litigating against any further weakening of the federal VRA. But at the same time, we can and must be proactive in strengthening voting rights. And the way to do this is through the states. The states can, and I would say must be, laboratories for democracy and create rights that go beyond the federal minimums. So Latino Justice worked with LDF, the Asian American Legal Defense and Education Fund, also known as ALDEF, the Campaign Legal Center, and the Election Law Clinic at Harvard to put together model legislation that was released in January. What it really is, it's a resource for grassroots advocates, for electeds and their staff, for legal advocates, and it's a model act that can be tailored, obviously, to local needs. So it really, the objective in these state model acts and through the model legislation we drafted is to strengthen provisions that have been diluted in federal law or are at risk of being diluted, such as the pre-clearance provision that shall be eliminated. So the state model has provisions that states can adapt to include pre-clearance provisions for state and local elections that in jurisdictions that have patterns and practice of discrimination. There are also in the Model Act provisions that really help prohibit voter suppression and vote dilution by establishing a cause of action to challenge in state court election practices that deny or abridge the voting strength or access of voters of color based on their protected class status. So there are provisions that go to challenging vote dilution, either packing or cracking certain communities like the Latino community into districts so that it would undermine the ability of each Latino to elect the candidate of their choice. It also has model provisions that go after practices that create barriers to voters of color, including things like inaccessible or insufficient polling locations in communities of color, or wrongful voter purges. I think so many of us on this call have litigated against voter purges over time. These purges disproportionately harm voters of color, or practices like holding elections on unusual off-cycle dates, or just election administration decisions or equipment allocation that lead to longer lines in communities of color. So this Model Act has provisions that provide tools to combat these specific practices. And it also has enforcement provisions. It allows voters to go to state courts to challenge election practices that suppress votes or dilute the electoral power of voters of color. Here in New York, we just won a case under the New York VRA that against the Nassau County, where we were successful in arguing that an original map was diluting the power of Black, Latino, and Asian voters, and it led to a settlement where the maps were redrawn. What's great is all of these model enforcement provisions enable states attorneys general to sue on behalf of voters. Very important because often individuals don't have the resources, the capacity to bring these suits, and the state AGs are such a great force for us. We talked earlier about limited English proficient voters, a big concern, especially in the Latino community. So we have model provisions that mandate that translated materials and assistance is provided for language minority voters, including groups that are not currently covered by federal law. So it goes beyond the federal minimums to allow more people to get that assistance. There are provisions that provide remedies for voters who face threats or an interference in their vote. This is really important now, given the current climate we're in, where there is really credible fear of federal law enforcement, intimidation at polls. So state voting rights acts, they're not new. Tom, I don't think Tom and MALDEF, for example, were very critical in the effort to pass a Voting Rights Act in California in 2002. It was the first SVRA in the nation, and there are voting rights laws in place in at least 7 other states. And we have about 9 other states where state voting rights acts have been introduced. And so I think right now, the effort that LJP and others are really putting into the state enacting as many state VRAs as possible is really critical. We want to be on the offensive and not just on the defensive.
Great. Thank you very much, Lourdes. So at this point, certainly if there are any reporters, anyone that has questions for any of our panelists, please feel free to use the Q&A function and ask questions. And actually, I saw one just come in from Hansi Lo Wong from NPR. And his question is, given how the U.S. Supreme Court allowed Virginia to purge individuals from the state's voter rolls within 90 days of Election Day 2024, how are you anticipating the National Voter Registration Act's quiet period will or will not be enforced ahead of this year's general election? So this goes to voter purges and the quiet period issue, the quiet period under the National Voter Registration Act. And I don't know if any of our panelists would like to address that question. Tom, go ahead. I think that you are raising your hand, so yes.
Thanks, John. Since no one else will come forward, I will. So, of course, the rest period before elections provided for the NVRA is critically important so that we don't have late disruptions of the rolls. Folks should not be informed without opportunity to fix any problems that they are somehow being removed from the right to cast a ballot. And that's what that rest period before an election is designed for in the NVRA. So yes, we are all concerned and monitoring for any attempts to exploit a loophole and somehow attempt to make changes too close in time to the election. What we want is a level playing field. We all have to deal with in our litigation the so-called Purcell doctrine that says we can't challenge state procedures or policies too close in time to an election. Well, we want the same for our side with respect to protecting the right to vote. And that minimally means enforcing the NVRA protected period And it's something that we have to guard against because there is too much of a willingness to try to suppress votes by acting late in the game and thereby attempting to prevent any opportunity individually or on behalf of a class to ensure that folks are restored to the rolls in time to be counted for the election. So it is definitely a concern. And John, if I might, I wanted to add one thing to Lourdes's great presentation about state voting rights acts, and that is just to say, as powerful as they are, the Calais decision forthcoming that Adriel spoke about could still put limits on what can be accomplished through state voting rights acts because Calais could base its reasoning on some interpretation of the Constitution that would apply beyond the Voting Rights Act statute itself and limit potentially what can be done in certain circumstances through Voting Rights Act. So I just want to emphasize that the Calais decision is of critical importance even to these other efforts to ensure that states can protect their own policy about ensuring that voting rights are protected.
Great, thanks, Tom. And Taifa, I see that your hand is raised, so let me turn it over to you.
Thank you, John, and I appreciated Tom's response, and I appreciate all of you who are attorneys who know this in and out. I'll just say that one thing that I appreciate about my team at Demos and all of the partners who are part of the voter purge table, which include many of you, we've developed an early warning system that at least, outside of some of the illegal efforts that may take place, we're able to alert the broader community about some of these purges and actions so that our litigator friends can, show up when they need to. So really appreciate this community so that we can be vigilant, like I said earlier.
Great, thanks, Taifa. Part of this, it seems that like what we're all talking about is just ensuring that people have as much access as possible. Because at the end of the day, it seems to this group, certainly, I think we are united in this notion that like elections should be easier than harder. And that's certainly something that is proven out in poll after poll after poll, is that people want to participate in our democracy, but they are being denied the opportunity. And I think that's why it's important for all of our organizations on behalf of our communities to be speaking out about these issues. Let's see, we have another question, also from Hansi. Thank you, Hansi. The Supreme Court justices are scheduled to discuss the cert petition in Arkansas United's VRA Section 208 case this Friday before Arkansas's responding brief is due on May 18th. Do you expect the Supreme Court to decide whether to take up the case before that brief is submitted? And obviously this involves some prognostication for those that are following the case closely. I don't know if any of you have any insights or thoughts about that, or what all of this means, the fact that they may be taking this up before the responsive brief is being submitted. Yep, go ahead, Tom.
So John, with respect to Arkansas United, the court has taken it up sufficiently to order a response on the cert petition. The defendants have asked for additional time. We don't expect the justices to act before that brief is submitted now on a delayed schedule. But I do want to emphasize that we really do see Arkansas United as following behind Turtle Mountain. So the court takes up Turtle Mountain. We have asked in our cert petition in Arkansas United that they simply grant cert and hold the case until there's a resolution of Turtle Mountain, because Turtle Mountain could resolve Arkansas United without having to touch the preemption issue. So a lot going on, but we don't expect Arkansas United to go ahead of Turtle Mountain, don't want it to. And so we have agreed, and now the court has granted an extended response period to the defendants in the Arkansas United case.
That's helpful. Thank you. I currently don't see any other questions from our audience members. Maybe I'm going to just ask a question of our panelists that probably is front of mind for a lot of people, which is around the SAVE Act, and particularly around documentation for citizenship. Because I think the common question that frankly a lot of us get asked is why is it so hard for people to prove citizenship? Isn't that easy? Isn't that a common sense approach that we should all be taking? I see hands quickly going up, so I will turn it first to Lourdes and then to Jacqueline on that. And you're on mute, so yeah, sorry. And you just got remuted.
I didn't do this. All right. I'm going to try again. Thanks all. The reality is, the numbers show that more than 21 million Americans don't have right now like a passport or a birth certificate that they can readily access to prove their citizenship. And it's really going to be a burden. I will use my own family as an example. My mother is 83 years old. She's a Cuban American. She came to the United States in the 1960s and quickly became a citizen. She is a dedicated voter, but currently she's in a rehab facility, right? She doesn't have a valid passport. I was down to visit her this weekend, and she asked me to go to the safe deposit box in her bank to see if her citizenship papers are there, and they're not. And so my mother is going to be disenfranchised if this, could be disenfranchised by this act when she's been a citizen and voting since the 1960s. And that's just not acceptable in our democracy.
Thank you. Jacqueline.
Yeah, I just want to emphasize the SAVE Act is a series of choices, right? Around what types of ID, what qualifies as ID, who is in the in group and who's in the out group, right? And I think that what we're seeing is that who's in the in group is incredibly limited and out of touch with reality of what many people, many communities have for their own documentation and have as, I think legitimate forms. And I think a good example of this in and out is sort of the red herring of allowing tribal IDs in the SAVE Act. Well, they also require a place of location of birth on the ID, an expiration, and a photo. And the truth is that you don't expire being native, and you also don't often in any ID really have the place of location of birth locate on the ID itself. And so unsurprisingly, tribal IDs don't have this on them. And so what we're seeing is this, I think, disingenuous attempt at inclusion when really it's about exclusion. And it goes beyond just sort of the IDs themselves, right? This idea of presenting proof of your documents, presenting your papers in person sounds easy enough if you live in a city. If you live in an Alaska Native village, that is a 1,000-mile plane ride to the nearest elections office. And this goes back to sort of the ways in which systemic barriers and inadequate mail or election services are provided in the first place, right? It's ongoing discrimination that there aren't election offices in rural areas disproportionately, and certainly not within Native communities, and forcing the voter to do the travel that the election officials say is too difficult for them to do. But now to have to show your papers in person would mean hundreds and potentially thousands of dollars to try and meet that requirement. Native voters that are disproportionately impoverished, that lack access to roadworthy vehicles, are just certainly not going to be able to make this trip. And so this is a bill that really is aimed at and would succeed in disenfranchising many of our communities.
Yeah, thank you, Jacqueline. I appreciate what you are saying also because, again, this emphasizes that for us, it's not about partisanship in any way because many of the people that are affected by these types of laws include people that live in rural communities, live on farms. I mean, in terms of people that have birth certificates, there's a much higher percentage of birth at home rather than in a hospital for people that live in rural communities. If you think about people that live in different situations, the likelihood of someone changing their name formally, legally, some having legal documentation after they get married, looks very different in rural places, in more impoverished places than they do in sort of more rich urban or ex-urban areas. So I think this goes to, you're absolutely right, Jacqueline, it is sort of thinking about sort of the myriad ways in which laws like this really affect and getting out, frankly, outside of even our own bubble at times of like, I expect that most people on this Zoom call probably have passports, but we're not representative of the national community. Um, Let me ask another question. Maybe I'll direct this to Audrey, because given that I know that the work that you all do at the ACLU, one of the things that I think a lot of people are concerned about, and we see it happening now at airports actually, is ICE presence at airports. We keep on hearing rumors about potential ICE presence at polling places in the fall. So how are you all thinking about that in terms of what that looks like, what the response would be, and how you would message to communities about that?
Yeah, thanks for that question, John. Yes, this is something we think about a lot, something that we are concerned about a lot and have been planning and working on a lot, starting with the last year's the special elections. I think, what we would remind everyone, what we did then, and we would continue to remind everyone, is that every eligible citizen has the right to cast a vote freely, fairly, and excessively without fear or intimidation. So the baseline has to be that any deployment of ICE or any law enforcement officers for the purpose of interfering with elections or for the purpose of intimidating voters or interfering with the right to vote would be unlawful. And voting rights advocates, lawyers, and in many states, the state's own attorneys general, or lawyers are standing by to challenge those moves. But on the ground, election day, for you, me as voters, I would say that voters should just be mindful of their rights as citizens as they head to the polls. They should be mindful that the government can't detain you without reasonable suspicion that you have or are committing a crime or an immigration violation. And we've been encouraging voters to remain calm, to never physically obstruct law enforcement, but again, make their voices heard as they've done before. We don't mean to minimize it. These are incredibly tense times, but people's rights as voters are the same as they've ever been. Their rights as citizens are the same as they've ever been, and we will continue to fight to make sure that holds true.
Great, thank you, Adriel. Given that I don't see any other questions right now, what I'm going to ask each of our speakers to do is I'm going to ask everyone a closing question, which is sort of, as you think about the elections and you think about our audience, which is the journalists that are covering the elections, we know that there's going to be a lot of twists and turns that are thrown at us. What would you offer as sort of one thing that reporters should be looking for, one big picture story or narrative that you would ask them to consider or keep top of mind as they cover this upcoming election? And maybe I'll start with Taifa and work my way around.
Thank you, John. As I think about this, one of the things that feels really important to name is this prevailing narrative about election security and how the media can sort of feed that misinformation or ensure that frame is not sensationalized. And I think, as we talked about the SAVED Act, which is a federal piece of legislation, which again is being negotiated almost as a negotiation away from an even more problematic piece of election legislation in the MEGA Act. But states are now trying to do copycat SAVE Acts. And as Lourdes mentioned, sort of states are this laboratory of democracy. We still have to be very cautious of what's happening at the local level and at the state level, because that is where the pain is going to be felt by everyday voters, and also the overreach that we're seeing at the national level. So I would just offer, all of us who are doing this work, particularly the media, that this what is it, a solution looking for a problem? These election protection, these secure election acts are really problematic on its face. And I just think that if we can be very methodical in our analysis, particularly as the stories are written about the things that are said, particularly from this administration or even state officials about security, about these very problematic efforts to restrict voters from their fundamental right to vote. I just hope that our media would help to frame these things up in an accurate and truthful and a way that helps the people understand the issues and not be sensationalized. So that's one of the things that I'm really sitting with as we move forward.
Great. Thank you, Taifa. Next, we'll go to Adriel.
Thanks, John. I would, I guess, encourage folks and reporters to broaden the scope and see many of the stories that we are seeing, and we will keep seeing as part of just a broad, very far-reaching, and sometimes it feels like multi-front effort to shrink who can participate in our democracy. I think at the center of it, you do have the SAVE Act, which would really make it incredibly difficult for many people to vote, as has been said here. But the SAVE Act is only one piece, and I think a lot of the issues that we've spoken about also just shrink the number of people who would be able to vote. The Calais decision, the Watson case that the court just heard yesterday, if it says that votes cannot be received and counted after Election Day, that again would be an anti-voter decision. And you take it down all the way to the intimidation factor and the fact that if law enforcement, if ICE is deployed in a way that intimidates people from going to the polls, that might have a suppression effect. This is all shrinking who would participate in democracy and who would participate in the 2026 election. So it's not all it can't all be viewed with a too narrow a focus, because it all sort of comes together to essentially shrink our democracy.
Great. Thanks, Adriel. Next, we'll go to Jacqueline.
Yeah, thanks. And just picking up on what Adriel is saying, the shrinking of the electorate is often among racial lines, right? And I think too often we lose that narrative when we veer towards talking about the stakes of one election or the politics of it all. And I think that here at the Native American Rights Fund, and certainly the partners on this call, continue to observe and fight against ongoing racial discrimination. Often, really, I think that it's lost that the communities that are being cut out along racial lines. And we can talk about how, that ends up diluting and minimizing and really disempowering communities. And that is the intention, right? And I think that we can't, forget that important part of the puzzle. And so I would encourage you all, if you need particular stories, individuals, incidences of racial discrimination, I know all of us encounter that reality day in and day out and are happy to share those with you. And we have to have a running theme of the news that's reported being that racial discrimination is still existing in 2026, and that all of us deserve the tools and the recourse when racial discrimination occurs in voting. Thanks so much.
Thank you, Jacqueline. Lourdes.
Thank you, John. I'm going to pick up on something Jacqueline said. For me, I would love to see the media continue to uplift individual stories of people who encounter difficulties or who will encounter difficulties in voting, because I think it's so important that Americans see that other people like them who work a job, who have children, who have elderly parents, who may have a disability, there's so many people who are encountering, obstacles to just voting. And the more those stories that are told, the more that people will understand that it is a big deal what they're trying to do, that in fact to ask for ID and it's unacceptable that people have to wait in lines for hours to vote when they're working and they have a job to get to, or an elderly parent to care for. So again, I would uplift the individual stories of the adversity that people are facing in voting.
Great, thanks. And last but certainly not least, Tom.
Thank you, John. I just want to echo Taifa, but probably use language I'm not supposed to use. But I think it's important to constantly reject the canard of voter fraud. Voter fraud is non-existent in this country and has been for 50 years. So when it is trooped out repeatedly, we should reject it immediately. Remind us that the first Trump administration created a commission that was going to prove voter fraud to all of us, and then quietly in the dead of night killed that commission a few months later. Why? Because they could not prove anything with regard to voter fraud. So reject as canard voter fraud, much like the outcome, the undeniable outcome of the 2020 election that is often denied. We have to recognize fact as fact. The fact is, the problem in this country is not over participation of ineligible folks in voting. It is under participation of fully eligible voters. And therefore, the burden is really on them to prove that that under participation is somehow replaced by ineligible voters. Not a shred of evidence to support that. We should reject that narrative and recognize that under participation of eligible voters requires different solutions, not the ones being offered up by the SAVE Act or any other proposals from the current administration.
Great. Thanks, Tom. I think I could probably summarize everyone's, as I listened to this, it sounds like there's three themes. One is that the barriers that are being placed are solutions in search of a problem. I think that's what Taifa expressly said. And I appreciate, Tom, you're using the word canard of a problem, right? Number two is that race is still an issue, and we cannot deny that racial discrimination exists. Barriers to voting based on race still exist, and that is something that needs to be addressed through things such as the Voting Rights Act and other vehicles. And I guess the most fundamental point, it sounds like it resounds with the panelists, is that restrictions to voting is literally anti-democratic. The purpose of a democracy is to be able to vote. And so anytime you are disallowing voting on the basis of imagined problems, that should be called out. I really want to thank all of our panelists for really helping everyone to understand some of these issues, both in details and in broad strokes. But I think both are very important in this moment as we hurl in some ways towards the midterm elections. For the reporters that have been watching this, I encourage you, if you want to get in touch with any of the individual speakers, have follow-up questions for them, you could contact all of us through teamvrwg@mrss.com. I'll repeat that again. It's teamvrwg, all one word, at mrss.com. Again, thank you all for participating. Thank you to our attendees for participating. And we look forward to hearing from all of you in the future. Take care.